Good morning, all. It's a great pleasure to have the opportunity to give a lecture on a topic that it's quite fascinating, especially this period of time. And it gave me also the opportunity to reflect back on what I had been teaching all this year in maritime law, but also to get reminded of those things that most of us teaching and practicing maritime law, we might have forgotten. So with any further ado, I will proceed with my slide presentation, and I will try to confine my presentation into 20 minutes or so. The title is COVID-19, which is a term that we are extremely affiliated with that nowadays. And I would like to see what is the effect in relation to maritime law by focusing on the place of refuge and ships in distress. Now, a good opening slide, quite maritime in its nature, but above all quite British in its origination, is an oil paint on canvas made by Peter Monamy, who is one of the first born English painters to have specialized in maritime themes. As you can see, the title of that painting is Ships in Distress in a Storm. For those that you have a maritime, slightly relevant to maritime law background, you will be immediately easy to pick up the legal terms, ships in distress. And although the title of the painting dates back to the 18th to the 17th century, which is a very important century for our discussion today. Is also very important for the law. So what actually in distress means for ships? So I will leave that question for the time being, and I will go back shortly to that. Now, a very close theme, but this time, you know, this slide depicts something real. It's the incidents of Erika and Prestige, two tankers which suffered pretty much the same fate in the very same place under same circumstances with 3 years apart. Here you can see Erika sinking off the coast of Biscay, and in the same place, as you can see, 3 years later, Prestige suffered the same fate, sinking. So what was the legal common connection between these two, and what is the nexus with the discussion today? Both of these ships had run into heavy weather, into storm, and suffered some structural inconsistencies in their hulls, which required that they should go into a port of safety, into a place where they could have repairs and sheltered by the weather. Nevertheless, the states of the region firmly refused access to these ships on account of an environmental threat. Both of these ships were very old. They were carrying a lot of cargo. In relation to Prestige, the cargo was over 70,000 tons, and therefore the states in the region, namely Portugal, Spain, France, pushed away that vessel, both of these vessels into the sea. And the outcome, as you saw, was actually, after wandering around for a couple of weeks, the condition on these vessels deteriorated and eventually sank, leading to extensive environmental pollution. So how that now relates to COVID? As we know, and this is the evidence that are being sourced through the World Health Organization, COVID is a pneumonia-based disease that originated in Wuhan, China, and in late January was proclaimed to be a public health emergency of international concern, receiving the formal name as we use it nowadays, COVID-19. Let's now put into the discussion the place of refuge and COVID together. Before we do that, I would like to say a few things about the history of contagious and infectious diseases. COVID, like many others that we know, they might sound known to us, but for good reasons we have forgotten. It's one of the pandemics that have shaped our history, and especially the maritime law history that we have forgotten, and I would like today to bring into light again. So COVID-19 in terms of contagious and infection disease is not something new for maritime law, but it certainly was forgotten for more than 5 centuries. We have since the 13th century in particular, we have other pandemics like smallpox, influenza, tuberculosis, rabies, HIV, which is within the list of infectious pandemics, but not easily contagious pandemics, cholera, yellow fever, that I will have a slide in relation to that, malaria, which is one of the traditional maritime diseases on board ships, Ebola. Very recently in 2015, we had the endemic in many states in Africa, Ebola affecting shipping. And of course, one of the most fearsome but long forgotten, and thank God for that, the plague. The plague refers to the spread of the bubonic and septicemic plague that arrived in Europe. And you can see the maritime route that facilitated the spread of the disease from the Orient. And at the time, it was the 13th century, the Genoa, it was the major port city in the known world. So the spread of the plague came on board Genovese ships. First time appeared in the Geneva port, and then it was spread deeper into Europe, arriving also into England around 1348. Now, we could say that at the time, ships and the maritime commercial trading areas, routes and areas facilitated the spread of the disease, as happened today with mainly the airliners and traveling by air. Now, this is taken from the New York Times in 1883, which covers a second very important pandemic, that of the yellow fever. And you can see that the drawing there depicts a British ship. You can see the Union Jack flag of the ship to approach the New York coast. And you can see the Board of Health, which was a public agency which was discharged and responsible to fight off pandemics and undertake safety and policy measures. You can see also some small details that I managed to decode. First, the fez, borne by the skeleton, which is actually a connotation of the yellow fever coming and originating from the east. And also you can see the bottles, which are turned like cannons towards the British ship. And the boat and the bottles, what they contained was actually carbolic acid, which is, you know, the scientific name for what we all use today, like this small bottle of disinfectant. Now, the Board of Health at the New York was responsible, as I said, to take preventive measures. And this was for the first time happened back in Genoa in the 13th century, which actually was the very first maritime port to establish the practice of what is called now quarantine. And we have been using, unfortunately, this term quite extensively this period of time to mention that we are locked down in a state of quarantine. But quarantine, it's a Genovese dialect which actually describes a period of seclusion. And in a Genovese dialect, it reads as 40 giorni, which means the big 40 days. And this practice was put in place in order to make sure that a ship, having been infected with a contagious disease, will not be a threat to the city and to the people of the city and to the extension to the normal life of that state. So what is nowadays the immediate effect of the current pandemic that we are facing in maritime law? It's quite extensive. It has touched upon all important maritime law issues. Charter parties, the contracts of hire of vessel and cargo. It has, in a number of cases, put off hire vessels in means that they cannot trade. That has resulted in demurrage and lay times. The fees that are being paid as extra because the vessel is held back. Also, it has raised issues of safe port and safe berth in relation to warranties, whether or not the ship is being sent in a safe port if that state is being infected with a contagious disease, or the vessel can actually depart from that place to go elsewhere. Important effects we have also in relation to the goods that are being carried. Excuse me. And especially that it's very important when the cargo is perishable, because on the top of the off-hire complications, we might have the devaluation and the total loss of the cargo. For example, you can imagine a vessel carrying bananas, which are perishable cargo, to be in quarantine for 40 days without being able to discharge its cargo or to take new cargo from a port. These are being covered mostly by insurance, although this might refer back to old insurance covers, which might be now disused, but nowadays came to the forefront once again. However, to my opinion, the most important issue, which underlines all of the above, it's something that is not very easily noticed by the maritime lawyers and the general public, and that is the freedom of navigation and the laws and the practices that allow a ship to navigate freely. And most importantly, a part of that principle that has to do with the freedom to access a port. And this can break down in four significant aspects, but I will only cover in more depth just one. The first one is the deviation. It needs to go to a specific safe port where probably it will not be able to discharge its cargo to the designated or owner of the charter party. It has to do with the seaworthiness, because if the crew is in a dire health condition, then the seaworthiness come into question for the vessel. If the vessel does not reach into port in time, it might have its certificates expired, not being renewed by port authorities. Even if it goes into a port in a place of quarantine, we do have important issues that affect the crew of the vessel, the human element, regarding the embarkation of new crew or other people, or disembarkation of the crew. Also, it will need to undergo very important inspection and vetting processes in order to make sure that the vessel does not pose any further threats to the port and the coastal state. And for a very narrow but yet very important occasion, when we have passenger vessels, this cargo, this sui generis of very special nature cargo, it becomes really important, like cruise ships. And I am sure you might have glimpsed from the news the headlines regarding the Diamond Princess that was operated by the Princess Cruise, one of the most known cruise operators. And that happened on late January and beginning of February. Just to give you an idea, the Diamond Princess has, together with the crew and the passengers, a total capacity of 3,700 people on board. So it's actually a very small town. In late January, it had departed as part of the cruise from Hong Kong, and it was en route to Yokohama, Japan. Nevertheless, at the time, it was when we became aware through the health organization that we are in front of a pandemic. So en route to Japan, it was notified, became known to the captain that one of the passengers that had disembarked in Hong Kong, the previous destination, it was tested positive with corona virus, which of course made very likely that the whole vessel had turned into a breeding ground for that infectious disease, and it was close to 4,000 people. Now, the vessel, it was en route to Yokohama, Japan, and it requested to disembark, to access the port and disembark as normal. But nevertheless, Japanese authorities refused entry to the vessel, which made a very important situation, which turned the vessel into a very important health and safety risk. So what happened with these people that need to get medical attention? Now, this controversy, of course, surfaced into the news, and this is the one part of the headlines. And eventually, after international political pressure, the vessel was admitted in the port of Yokohama. But let me carry on with my discussion, and I will go back to that incident in order to be able better to evaluate what happened there. So access to ports, although it's a very normal and common tradition nowadays, it's also something that has not been properly recorded into our laws. So it has a very strong but very volatile and uncertain, in that way, customary basis, and it's better in the geese of law seen as a long maritime tradition. The treaty practice in the 10th, 11th centuries, the Italy practice does not sanction that as a commitment to receive any vessel, and more or less even, a vessel that is in distress, but is being as a mutual allowance between states to treat these vessels with all kindness and humanity, and to provide all friendly protection. And this is actually the legal language We don't know what actually means kindness and humanity, but we can, understand various forms that these can be demonstrated. Even today, the contemporary practice in a number of multilateral treaties does not give free access to any vessels, including vessels in distress, but there is a balance between rights and freedoms of the coastal states and the rights and freedoms of the ships in terms of navigation. In a very important treaty, UNCLOS, we do have even a very strict qualification of this balance of the respective rights. Now, let me go back into the slide with the Diamond Princess. Why the Japanese denied entry into the port? At the time, and that was on the 3rd of February, the passenger vessel, the cruise ship, had been tested through medical kits that had been dispensed by the Japanese authorities in the middle of the sea with 542 incidents. So on board the ship, we had almost 600 confirmed cases. At the same time, in Japan, which is a very densely populated place, the tested positively occasions were only 72. So you can see the balance of interest. You had a huge cruise ship having almost 6-7 times bigger numbers than Japan itself, and therefore Japan was afraid that having that influx of COVID-19 occasions will put in danger the public health of that state. Going back, and this is very close to my end for to the end of my presentation, I have referred so far to distress, and this goes back to my first slide. So what is distress? It's a legal term, and it's quite affiliated but very much confused, especially from the commercial law side, with force majeure. And force majeure, it's another Latin expression which dates back to this kind of long maritime history. Force majeure, it's an act that is being brought about by an irresistible force on an unforeseen event. And this leads to a person or an entity to be impossible to perform an obligation due to that event. Distress, on the other hand, it's something quite different. Distress, it relates, to start with a force majeure event, but distress covers exclusively only situations where the human life is in peril. So, for example, like the scenario that we saw with the cruise ship. Also, a very distinctive characteristic with the force of majeure is that in the force of majeure, confronting an irresistible force, there is no scope for action to be voluntary. So we act in involuntary way. While in distress, we act consciously. We know that we cannot perform an obligation in order to do something else, and that something else is to save life. For example, that was the legal underlying argument for the cruise ship to exert pressure into the Japanese authorities to get access eventually into the Yokohama port. Now, my very last slide tries to bring all together this and asks whether or not we need to revisit the doctrine. And what is the doctrine? The doctrine is that nowadays we have been reminded that they can be very important situations for place of refuge that go beyond environmental considerations, like in Erica and in Prestige. And these considerations have to do with human life, something that had not raised any concern for 6 or 7 centuries now, but now by looking at the incident with the cruise ships, it became possibly a probability now and in the future. So we need to go back and revisit a number of important conventions which have not been drafted with that kind of situation in mind. The Safety of Life at Sea, the 1974 Convention with the International Safety and Management Code, which aims to deal with these kind of situations. The Convention on the Facilitation of Maritime Traffic regarding entry of vessels into foreign ports, and you can see that this is as well a very old convention, 1965. We did have amendments in 2005, but these did not cover incidents of that scale. And now we do have as well a political framework in order to be able to set off that legal process towards something more concrete. And in the space of 4 months, from January up to May, the IMO, the International Maritime Organization, issued more than 15 extensive circulars, which of course do not have any legal bindingness, but offered as a consultancy to states to deal with this matter. So we do have a lot of things to cover ahead of us and in terms of law. And I hope that this at least gave you the very broad picture about the COVID situation, the maritime law, but in terms of navigation, which is the angle that I chose to approach that matter, something that has not come quite clearly yet in the news. But it's up for us, for the maritime lawyers, to go into more depth, looking back at the history, but also ahead to the future in order to shape new law. Thank you.